The judge presiding over the subway chokehold case dismissed the top manslaughter charge after the jury had difficulty coming to a unanimous verdict in the subway chokehold trial. The Manhattan jury declared itself deadlocked on the top charge against Daniel Penny, who was accused of causing the May 2023 chokehold death of Jordan Neely. The jury sent a note to the judge saying that they were unable to come to a unanimous vote on count one, referring to the second-degree manslaughter charge. According to the verdict form, the jury must first decide on this primary count before considering any additional charges, including criminally negligent homicide. The prosecution moved to have that primary count dismissed, making room for Judge Maxwell Wiley to order the 12-member panel, comprised of 7 women and 5 men, to return next week to consider the lesser charge of criminally negligent homicide against the former Marine. Here's some reaction from outside of the courthouse.
We saw the jury having a problem with the top charge. We saw a judge dismiss the top charge. But I want to take you back to jury selection. When they found a jury specialist who specializes in getting white supremacist killers off, who specializes in race-based jury selection. This woman worked OJ's case. She worked Kyle Rittenhouse's case, the person who bought an AR-15 to a Black Lives Matter rally and killed people. She worked that case, and they paid her I don't know how much money to come in here and pick this jury. Now, I want y'all to quote me on this. America is going to America. And this defense team and jury specialists knew that there was no way you could put 9 white people in a room that would find Daniel Penny guilty. They picked a white supremacist jury specialist to target the racists in that jury. The prosecution pointed out the fact that defense was eliminating people based on race. Let me take it back because I don't want to scare y'all. Logically thinking, if you pick a white supremacist jury specialist and you pack the jury with white people, obviously you think race has a significant role in this case, and obviously you were looking for that one white supremacist holdout. That one holdout. Might have been more, but there was definitely one person in there that said, I'm not going to convict this white kid for killing that poor little mentally ill Negro piece of trash. Forgive my language, but I'm proving a point. This is how they think. The defendant himself called Jordan a dirty crackhead. And the police let him go. The police found inconsistencies in his story and allowed Daniel Penny to walk free. When does that happen for black people? Am I not making my point clear enough? Racism has its tentacles all over this case. Racism has its evil tentacles all over its case and all around the minds of white America. Are all white people bad? No. The prosecution did a phenomenal job. The judge is trying his hardest to bring justice to Jordan Neely's name. But racism is still alive and kicking in America. There's no other way to view this. Everyone has looked at the case, and those among you who say that Daniel Penny is innocent have racism and bias in your heart. If you look at the facts of this case, then you understand that Daniel Penny is guilty. But today, white supremacy got another victory. Today, the KKK, the Klansmen, the evil in America got another victory. They got that top charge dismissed. America shall continue to America and shall continue to place second-class status on black people. And black people, don't get your hopes up. I'm going to spare you the shock. Even if convicted of the top charge, he wasn't getting more than 4 years. We don't get justice in these buildings. They might throw us a crumb here and there, but we don't get justice in these buildings. And I dare you to show me a study or some case law to prove that, to disprove that.
I stand here heartbroken because I have to hug a father who knows that the murderer of his son will most likely go free, who has to look in the face of a jury that no matter the facts, no matter the expert witnesses, no matter the people yelling on that train that day to let Jordan go, you will kill him. They will not find a white man guilty of killing a black man in modern day America. This is no different than Jim Crow. This looks like a picture out of the picture book when you look at that anonymous jury. We have baby boomers who were there doing Jim Crow on this jury. We have young people who are looking at Daniel Penny as a hero. And what America is a hero, a killer. He didn't give a crap about Jordan. The medical examiner said Jordan turned purple. Yes, black people can turn purple when they're denied oxygen. Every lab report showed he died of asphyxiation. And that doesn't matter because they want to spare a white man the penalty of his crimes. America has not changed, and I hate to say it, it may never change. And people who keep asking, are we going to riot? Are we going to protest? Is that what's needed? Do glass have to break? Do cars have to burn for a black man to get justice in America? We can't show up with peace. We can't show up with facts. We can't show up with evidence and witness after witness. You give us nothing. And then you ask us to love this country. America hates black people, and we see it from that jury pool.
All right, certainly a lot of passion there. But meanwhile, Jordan's father, Andre Zachary, filed a civil lawsuit against Penny for negligent contact, assault, and battery that he says led to Neely's death. The New York medical examiner concluded it was Penny's chokehold that killed the 30-year-old. Neely's father is requesting damages, as the filing put it, in such sum as a jury may find reasonable, fair, and just. I'm now joined by my panel, Michael Imhotep, host of the African History Network show out of Detroit, Michigan, Kelly Bethea, communications strategist out of Washington, D.C., and Matt Manning, civil rights attorney, comes to us out of Corpus Christi, Texas. Matt, I want to start with you because really we are talking about a jury that was deadlocked. Certainly a lot of people you could ask on the streets might call this man a hero. Plenty of people say that this man was certainly not a hero. Now we're looking at the jury, they were deadlocked. What do you think was going through their minds, even after the judge gave them an Allen charge, saying to them, go back, try again. You really need to come up with an answer here.
I don't know what was going through their minds. I do know that often the law does not work in the way that we think it should work. And I think this is one of those cases. But in reading the article, one of the articles in preparation for today, a fact I did not know that I think may have had a large bearing on this jury's inability to reach a verdict is the fact that I guess around that time there had been something like 20 people shoved in front of subways. I don't think that makes Daniel Perry's position in any way reasonable. But what you look at when you look at self-defense and when you look at, any defense to a homicide is you look at whether the person's use of deadly force, at least in Texas where I practice, the use of deadly force to protect themselves or a third party is reasonable. And I think, what may have happened is the jury may have been swayed by arguments that it was reasonable for him to use this force because people on the train were concerned about what this young man was going to do. Now, I don't think that that's reasonable. I think, if he had actually attacked someone, if there had been a physical altercation, we'd be having a much different conversation. My understanding is that he was not physically attacking anyone. And that to me, which is, I suspect what the prosecutors did, I would have beat that drum in the courtroom and said, you don't get to preventatively assume someone's going to do something harmful and then protect yourself against them when it's unreasonable. Now, obviously, the law allows all the time where if your belief is reasonable that the person is about to imminently use deadly force, you can definitely use force to protect yourself. I don't think this is a situation where the use of that or the facing of that force was imminent and was reasonable. And that's what I really think is the primary question here. And as people, may know out there, all you need to hang up a jury is one person. So we keep talking about the jury, but it's very plausible that there were 11 people in that box who thought he was guilty of sin, and there was one person who was holding out. And if that one person holds out, then you have a mistrial. So without knowing how the jury, is constituted in terms of guilty versus not guilty, you can only extrapolate that there was not unanimity, which is what's required. And the last thing is, an Allen charge is a charge where the judge tells the jury to continue working. I think you said that. And yes, those are not applicable in every state. I think that obviously the state of New York allows it, but basically the court tells the jury, hey, keep trying, keep working at it. It looks like the jury was given 2 Allen charges in this case. And in cases I've tried, I've had it where, there have been mistrials declared where a jury has not been unanimous. So I think it might be the fact of people who had been harmed around the subways around that time. Maybe that was given outsized importance in some of the jurors' minds.
All right. And we don't have Kelly Bethea, but we do have Joy Chaney. Sorry about that. Founder of Joy Strategies out of D.C. Joy, I want to throw it to you right now to ask you, what are your thoughts about this whole idea that the prosecutors did ask for a lesser charge? They dismissed that top charge in order just to get something and in hopes that they probably will.
Well, absolutely. I mean, that's normal, right? So, you can have multiple charges out there. If you feel like the top charge is too heavy, there are other charges, other things that he might be guilty of. And that likely happens. Sometimes the prosecution may overcharge a little bit in the jury's mind, but a juror might feel like, this fits a lower offense. I would like to say the thing when you say a reasonable person is it's not every reasonable person. So they look at what are the skills of the person. So what is true of a police officer, what is reasonable for them would be less reasonable for all, or more reasonable for all of us, right? So I think that they should have been looking at what is reasonable for a civilian, but who is a former military officer, former Marine with special skills, who should have had some indication of the pressure he was applying, the deadly nature of what he was doing, that he wasn't just subduing him, but that he potentially ran the risk of killing him, which ultimately he did. And then the fact that there were people calling out to him while he was doing this, saying, hey, he's subdued, he's suffocating here, suggests that maybe, that he was not acting reasonably. And so I would be really surprised, I guess, at some point we'll find out how many jurors, perhaps, I don't know what the rules are in New York, but many places you can poll the jury afterwards and kind of figure out what was the sticking point. I would have a hard time believing most of these people weren't very concerned with the fact that other people who also could be perceived as reasonable were seeing something totally different than the perpetrator here. Very disturbing, this result, but not surprising. And I'm curious to see what happens with the lesser charge.
Michael, the defense team has argued that, listen, there were women and children around and that their client was making sure that nobody got hurt because he did have special skills. In fact, a martial arts expert did take the stand, though he did say that over 5 seconds was probably not a good idea for a chokehold. But what do you think about this argument that they have made that he was really defending the people in that subway? Because as we know, subways can be very dangerous. A lot of things can happen, but what are your thoughts?
All right, Candace, I think that question is for me. You're doing a great job tonight. I'm having a little problem with the audio, so I'm not exactly sure what you just said, but I've been paying attention to what's going on with today's development. So, number one, I'm glad you showed outside the courtroom where the gentleman talked about the white supremacist jury specialist, okay, because in following this case and also looking at the video footage, and we talked about this on Roland Martin Unfiltered back when this originally happened and Daniel Penny was indicted. I talked about the fact that if you want to restrain a person, you do not put a chokehold on a person. If you use something like a rear naked chokehold, which cuts off the flow of blood to the brain. You can knock somebody out in 10 seconds to 15 seconds. Daniel Penny is a former Marine. Most likely, if he was in the Marines prior to 2002, he was trained in the Marine Corps Martial Arts program. It's called MCMAP. I've researched MCMAP. I'm very familiar with it. I have a background in martial arts. If you go on YouTube, you can see videos about MCMAP. MCMAP is a combination of 17 different martial arts forms, and the Marine Corps has compiled this into one fighting system. And you learn chokeholds. Okay, now, according to the article from NBCnews.com, he only wanted to restrain Jordan Neely. Okay, well, if you want to restrain somebody, you don't put a chokehold on them for 6 minutes. Mm-hmm. Okay, if you've been just through basic training, you learn how to kill people. Okay, so, and you learn that you cannot have a chokehold on somebody for 6 minutes when you can render them unconscious in 10 to 15 seconds. So, hopefully on the lesser charge of negligent homicide, he will be found guilty. Now, the maximum penalty he can face is 4 years in prison for negligent homicide. Yes. The other thing is that if African Americans see somebody being attacked like this, an African American being attacked, especially by somebody white, possibly being executed, we need to intervene to break that up. It's one thing to be fearful of somebody and want to restrain them. Okay. Now, when you talk about restraining somebody, I'm not an attorney, but it sounds like, you do have, there is a possibility also when trying to hold somebody facing false imprisonment charges as well. That's a whole nother conversation. But this is this is a tinderbox right here. Now, the medical examiner said that Jordan Neely died from compression to the neck from the result of a chokehold. Of course, the defense attorneys disputed this, but this is clear how he died. So trying to figure out where the confusion is in the jury, this is something that we need more information on. But I would not be surprised if you have a white supremacist who snuck onto that jury and is holding out.
Yeah, a lot of passion in that statement that we heard. Certainly, we don't have any information about that, but it certainly is something that we will be following.
Hi, I'm Isaac Hayes III, founder and CEO of Fanbase. Fanbase is a free to download, free to use, next generation social media platform that allows anyone to have followers and subscribers on the same page. Fanbase was built through investment dollars from equity crowdfunding from the Jobs Act. People just like you help build Fanbase. And we're looking for more people to help build Fanbase. We are currently raising $17 million in a Regulation A crowdfund on Start Engine. We've already crossed $2.1 million, but we're looking to raise more capital from people just like you that deserve the opportunity to invest in early stage startups without having to be accredited investors. So right now, I'd like you to go to startengine.com/fanbase and invest. The minimum to invest is $399. That gets you 60 shares of stock in Fanbase right now, today. And then use Fanbase to connect with friends, grow your audience, and be you without limits.